Hello and welcome to CNBC-TV18 Newsmaker. India has a new labour law regime in place. 29 colonial-era laws have been repealed or rationalised into 4 new labour codes. The stated aim is to modernise the legal framework, extend social security to a wider workforce and ensure universal wage protection. However, trade unions affiliated with opposition parties have announced nationwide protests. So how do the new labour codes change the landscape? Let's focus on some of the big changes. First, the central government will be fixing what it calls the floor wage, taking into account minimum living standards across geographies. The states, however, will have the power to fix the minimum wage rate, which shall not be lesser than the floor wage fixed by the centre. Second, and this has been a major bone of contention for trade unions, the law gives smaller companies more flexibility when it comes to laying off employees. Companies that employ more than 100 people needed government approval before layoffs. That threshold has now been increased to companies that employ over 300 people. Third, the gratuity eligibility timeline has been eased as well. Fixed-term employees who have completed a year of continuous service are eligible for gratuity earlier. The provision mandated 5 years of service earlier. And lastly, the new codes give gig workers legal recognition. This had been a long-standing industry demand. Platform companies could see limited short-term financial impact as well. To take this discussion forward, we're now joined by Vandana Gurnani, the Labour Secretary. Ms. Gurnani, thank you very much for joining us on the programme. Let me first ask you about how the government will go about setting the floor wage, and is this going to be revised annually?
Parikshit, this floor wage, as you said, is an important concept. Floor wage was there earlier also. However, it was not mandatory. It was an optional kind of a floor wage, which Government of India used to fix at regular intervals. Now, as per the new codes, the floor wage is going to be having a statutory backing, which means it's mandatory, and no state should fix their minimum wage below the floor wage. The floor wage would, as you said, look into the minimum living standards, and there would be a committee of experts that would be deciding on what should be the floor wage, and these would be periodically revised upwards.
Right. Could you give us any indication of what kind of floor wage the government could propose initially?
We cannot give a figure till the committee of experts sits on it, because there is a full committee of experts, including statisticians who examine the entire data and who look at the various components of a minimum living standard and then fix the floor wage. So it has to go through that entire process of consultation by an expert committee, and then only it would get announced.
By when do you expect this floor wage to be decided, ma'am?
As I said, the committee will be formed now that the code has been notified. The committee will deliberate, and in the course of the next few months, the committee would come out with the actual floor wage.
All right. Now, I also want to ask you about the workers that are mandated under the labour codes. Does an 8-hour work day, 48-hour per week, work week, apply to all professions?
Yes, it applies to all professions. So it is, the outer limit is the 48-hour per week, and anything beyond that will attract an overtime, which is at the rate of twice the wage that has to be paid.
Could you also give us a little more sense on how the overtime will be calculated? And will this overtime wage also apply to professions like broadcast journalism, for that matter?
As I said, this is applicable to all sectors. The application, as I said, the normal working day is 8 and a week is 48. However, there is flexibility within that. There would be days where people could work for 12 hours. There would be days where it could be 9.5. There would be days where it's 8 hours. If suppose somebody is working for 12 hours, it's a 4-day work week, then 3 days are to be paid holidays. If they work on the 4th day, then that attracts an overtime. So I hope this kind of a calculation explains this. The logic for doing this was that sometimes in an establishment there is a requirement for a peak kind of a demand for work and workers, which is why this flexibility is now given that with the 48-hour work week, the appropriate authority, which is the central government or the state government in their respective domains, would be fixing the hours of work that can be done in a particular day.
Right. And
but
how will the government
the normal is 8 hours and 48 hours and beyond that is the overtime. But within that 48 hours, they can adjust
that,
on a daily basis. No, government will give that flexibility to the establishments. Government will not decide it for each establishment. The appropriate government in the states would notify this as part of their rules.
Right.
But the establishments will fix on a daily basis what exactly would be the days of work.
But
they can vary it from worker to worker.
But overtime payments would be mandatory?
Overtime payments were mandatory even in the previous acts, and overtime payments are mandatory even now, beyond these working hours.
Right. I would also like to ask you about the increase in contribution towards gratuity and provident fund. How is it going to increase under the new labour codes?
Can you repeat the question, please?
Could you give us a sense of how contributions towards gratuity and provident fund increase under the new labour codes?
Gratuity, as you spoke, was the change here is in terms of the fixed term employment. The codes provide for a fixed term employment, which is for a particular period of time. Instead of a permanent employment, there can be a fixed term employment. This will actually move people more towards formalization, because currently a lot of people are taken on contract because there is no provision for fixed term employment for a certain period. Normally, for project-based work, a lot of people are taken on contract. They can be taken directly on a fixed-term employment, and they, after completing about a year of service, would be entitled to gratuity. In terms of social security contributions, as you know, are linked to the definition of wage. The wage definition has basically the basic plus the DA. There are companies which give a lot of allowances over and above this. If the allowances exceed 50%, then the excess over 50% gets added to the basic plus DA. To that extent, the social security contributions, especially for provident fund, which is a percentage of the wage, are likely to go up to the extent that they are more than 50% over and above the basic and the DA.
Right. Now, the threshold for government approval for layoffs has increased from 100 to 300. Is this for all sectors?
The threshold for 100 to 300 actually is, as per the code, it is specifically for industrial establishments, which is factories, mines and plantations. And since you mentioned it, I'll also like to explain the logic for increasing this to 100 to 300. So what it essentially means is that earlier, if a company, which is a factory, had to close down or retrench or lay off workers, it had to take government permission if it had 100 plus workers. The result of that was that a lot of factories would have slightly less than 100 workers directly employed and rest through contractors, so that they could not come in the ambit of this condition. Now this has been increased to 300, so which means that up to 300, the companies would be now encouraged to take people on direct roles with themselves instead of taking them through contract, because it's only above 300 that they would need to take permission for any retrenchment, layoff or closure from the government. So this, in a way, this actually increases or encourages formalization, and this is an aspect that needs to be understood more clearly.
Some have said that this increase in threshold would make it easier for mid-sized firms to hire and fire. How would you respond to that? See, as I said, that this conceptually, this 100-300 is
not meant to replace the regular or the permanent employees. It is actually positioned in such a way that when the companies were hiring people through contractors for seasonal work or for project-based work, instead of going through a contractor, they could directly hire those people for a fixed term. Now, this I would say is a win-win situation, because for the employees, they get the benefits of a regular employee in terms of entitlement for leave, maternity benefit, as well as gratuity after completion of 1 year. In addition, the employees get the benefit of working directly with the company and not through a third party or a contractor. That's I would say a big benefit for employees, because it meets their aspirations of working directly with the company. It also increases their employability, because they have directly worked with the company, and this embellishes their CV and biodata that they have directly worked with the company. So these are the benefits to the employees. For the employers, instead of going through the contractors and paying the contractors commission and fees, they could hire these workers directly for a defined period of time. So the intent has never been that this should replace permanent employment. The intent is only to make sure that what was happening through third party or contractors could be now directly engaged for a period of time with commensurate benefits as the regular employees. And if there is any violation for this, there are legal safeguards which are there in the courts, including the tribunals, which are now going to have 2 members, one judicial member and one administrative member for faster disposal of cases. Also, there are grievance redressal committees which are provided for in the code, where the workers have a proportionate representation, and also women have a representation in these grievance redressal committees. So with all these safeguards, as I said, this is not meant to replace regular employment with fixed term employment or to do hire and fire. It's to basically ensure that people needed for project based or limited period time get that kind of employment along with the commensurate benefits.
Right. When it comes to work from home facility, the code and the government's release says that this has to be by mutual consent between the employer and employee. So how will this be decided as to when can an employee work from home and when he has to work from office?
Work from home provision has been made for women after availing maternity benefit, and this is basically for the services sector, and this has to be decided based on the mutual consent between employer and employee. The specific goal of this provision is to improve women's participation in the workforce.
Right. When it comes to pay parity between men and women, what does the Labour Court seek to achieve, and what are some of the guardrails you have tried to implement to ensure the right working conditions for women to work in, rise in the workforce, and have access to equal pay?
You've raised an important point. The Code on Wages has some very, I would say, pro-worker provisions. First of all, it universalizes minimum wage, which was earlier restricted to about only 30% workers whose employment was in the scheduled employment. Now, the minimum wage is universal. There has to be no discrimination on grounds of gender, whether it's for men, women, or transgender, who have also been included now. There has to be no discrimination in terms of employment. And also, there will be, as I said, grievance redressal committees in the workplaces, which will have an adequate representation of women if there are any such grievances that they have in terms of terms and conditions and in terms of wage, etc. Also, the advisory boards which are going to fix up the wages, they will have both at the central level and at the state level. We'll have advisory boards which are going to fix the minimum wages. They will have 1/3 representation of women. So every care has been taken that women's voice is on the table, both at the policy making and also at the workplace.
Right. How does the labour law reform help gig workers? How will this increase the expenses of employers when it comes to giving benefits to gig workers, especially around social security?
So, gig workers actually for the first time have been given a definition in the code, because this is a new kind of a work which has come up thanks to the digital progress that has happened in the country. The gig workers are going to get several benefits. There would be a social security fund that would be set up for them. There would be a social security board which will have a tripartite representation from the gig workers themselves, from the aggregators or the companies, and from the government, which is going to overall monitor and oversee the social security efforts for the gig workers. The aggregators are to provide 1 to 2% of their turnover, subject to a maximum of 5% of the payout to the workers into this fund, from which the social security benefits, including pensions, accident insurance, etc., will be provided to the gig and platform workers. In our discussions with the aggregators, there has been no specific opposition to creation of this fund and this contribution. In fact, most of the aggregators were keen for a national law, because in the absence of a code, there were laws being prepared by the states, and they would have had to contribute to funds set up by different states. And the platform, the aggregators were always insisting on a national framework, a national fund, and a national contribution by them. So in that sense, they have been consulted and they are fully on board as far as the social security provisions for the gig and platform workers are concerned. And I think it is our combined duty for this new world of work that has come up the world over, as well as in India, to make sure that we provide them the required social security.
Does this code also apply to daily wage construction contracted labor?
Yes, it applies to the building and construction workers. There are provisions for their safety, for their welfare. Again, the states have the building and other construction workers boards, into which the people who do the construction, the developers and the agencies who construct, they are supposed to give 1% cess of the entire cost of the construction towards a fund, and that fund is to be used for the welfare of the building and other construction workers, for their social security, for their welfare, for their skilling, for their children's education. So there are a whole lot of such welfare measures that these state boards take up as part of the measures for the building and other construction workers.
How will this law support unorganized workers? What has the law done to support them?
See, for the very first time, the law has created for, or has provided for, social security for unorganized workers. And therefore, for unorganized workers also, for their social security, a fund would be set up. This fund could have contributions from their employers. It can have their own contributions. It can have contributions from CSR. It can have contributions from various fines, etc., that are collected. It can have contributions from the state government, the central government. So there is, first of all, a fund that will be created, a board will be created, and from this scheme will be designed to provide them social security, which would again include pension, which would include health benefit, maternity benefit. It would include life and disability cover. So these would be the kind of benefits that will flow to them. They would all have to be registered on the eShram portal, giving their Aadhaar, and all such benefits would be organized to be transferred to them through the DBT mode into their Aadhaar-linked accounts. Similar kind of provisions would also be there for gig and platform workers, who would have to register on eShram through their Aadhaar and get the benefits through an Aadhaar-linked bank account through the DBT mode.
One will now require a 60-day notice to call a strike in an industrial establishment. Will this defeat the entire exercise itself? It's
actually a minimum 14-day notice that has to be provided. In the previous acts, this provision was there, but it was only applicable to public utilities, and this has been now extended to all establishments. And the reason for this is to promote actually industrial peace and harmony. When a notice is given, it prevents disruption of the processes, but at the same time, it provides an opportunity and occasion for the workers and the management to sit across and to do conciliation and to resolve whatever grievances or demands of the workers are there. So, which is why it is actually to promote industrial harmony without causing sudden disruption.
Now, the labour laws have always been considered archaic. How have you decriminalized certain provisions of the law?
So there have been, I would say, huge changes in terms of the way these laws have been framed. They have consolidated 29 previous acts. The number of rules and sections have come down to 1/3 of what they were originally. Decriminalization, we had earlier 87 sections in the previous acts which were having criminal provisions. These have been brought down to 22. So the ones which were very technical and procedural in nature, like maintaining registers, etc., they have been decriminalized. However, offences which are grave or serious in nature, for example, those that can cause injury or disability or death, those have still been continued as criminal provisions. And provisions where, say, a social security contribution has been collected from the worker but not deposited into the concerned provident fund or the agency which is providing the provident fund or the trust, then that would be criminal provisions. Rest, the procedural and technical provisions have been decriminalized. At the same time, the entire digitization of the compliances will also ensure that there is better oversight by the supervisory officers on the compliances and will ensure better compliance. At the same time, the web-based inspection will make sure by using algorithms and AI that the inspections are targeted to organizations which are likely to default or which have defaulted in the past. So this will all ensure that the compliance is better through the digital means, but at the same time, the procedural and the technical provisions have been decriminalized.
My final question to you, working hours have been capped at 8 to 12 hours per day, 48 hours per week. But this cap was there earlier as well. As you're saying, ma'am, the clause for overtime payments was mandatory earlier as well. But that was never really followed in spirit. It is not followed in offices, industrial establishments. Will there be certain mechanism now to ensure that this happens?
So as I said, one is we have the grievance redressal committees which the workplaces will have to have, which are going to have proportionate representation from the workers. So that is a mechanism that is there. The industrial tribunals have been broad-based so that they can have faster disposal of cases. So these are the kind of legal measures that have been put in place to ensure. As far as the machinery is concerned, as I said, with the digitization that will happen, their time would be freed up to be able to go into these kind of violations because now they will be focused on actual violations since everything would be digitized and not manual.
All right. Thank you very much for joining us, Ms. Vandana Gurnani, explaining us comprehensively the details of the labour codes which have come into effect. That's all we have time for on this special program. Thank you for watching. Goodbye.